Hello, everyone. Good afternoon. This is a little hard. Hold on.
Oh no.
Since I can't see you, let's go ahead and get started. I'm so sorry that I am not there with you in person. I had planned to be, but life got in the way. So anyway, I wish I could see you all, but thank you so much for having me. Good afternoon and good morning to Rashid. I know it's early there for Rashid in Malaysia. My name is NEHA MISRA, and I am the global lead for migration and human trafficking at the Solidarity Center. The Solidarity Center is the largest US-based international worker rights organization, helping workers attain safe and healthy workplaces, family supporting wages, dignity on the job, widespread democracy, and greater equity and at work and in their community. I want to thank IHRB for inviting me to moderate this panel and for including this important topic of repayment and remediation of fees to workers. While we are focused specifically on remediation of recruitment fees on this panel, our conversation will necessarily cover remediation of all sorts for worker rights violations for migrant workers all along supply chains. As noted by Fair Square in their important 5 corridors report, unfair recruitment practices may begin when workers have to pay exorbitant fees, but they ripple through the life cycle of a work contract, leaving workers acutely vulnerable to trafficking and forced labor. 10 of the ILO's 11 indicators of forced labor link directly or indirectly to unfair recruitment. Yet, while commitments to eradicate trafficking and modern slavery from supply chains abound, functioning models of ethical recruitment are few and far between. That was a quote from the report. I'm so pleased that we all agree on the employer's pay principle. If we had talked 15 years ago, that may not have been the case. So while we agree on that, I'm hoping we can agree on this next thing. This principle will mean nothing unless there is a robust and fair system for repayment and remediation of fees and other violations of migrant worker rights in the migration process, in the workplace, and all along supply chain. We found consensus around the employer's pay principle. I now hope that we can find consensus on centering of worker agency in the remediation process. First and foremost, to achieve this goal, we must ensure that workers are centered in the remediation process. The key players are not only governments and employers and, quote, other stakeholders. Migrant workers are not other stakeholders. As recognized by the International Labor Organization, workers are on equal footing with governments and employers in industrial relations. And in terms of repayment and remediation, the affected workers must have their agency recognized. We must recognize not only worker voice, but migrant worker agency. Migrant workers have agency, including collective agency, to ensure fair remediation for recruitment fees and other violations. Worker representatives must be involved in the decision-making process before any remediation package is finalized and implemented. I hope by the end of this panel, we can all agree on that principle as well. Within this context, I'm pleased to introduce, we have 3 panelists for today to talk about their experiences on remediation. Excuse me. I'm not going to read their full bios, but just do a little bit of an introduction. First, we're going to hear from ANASUYA SYAM. ANASUYA is the Human Rights and Trade Policy Director at the Human Trafficking Legal Center. She leads the Human Trafficking Legal Center's initiative on import bans and forced labor. ANASUYA works with pro bono counsel, civil society groups, government, and other stakeholders to push for greater accountability through the enforcement of the U.S. Tariff Act and the Uyghur Forced Labor Prevention Act import prohibitions. Next, we are going to hear from REDZA, Anwarudin. He is the Chief Sustainability Officer at Sim Darby Plantation. He was appointed Head of Group Sustainability of Sim Darby in January of 2020. In this role, he was responsible for implementing on-the-ground programs to promote responsible and ethical production through Sim Darby's operations and global supply chain. He also engages with a wide range of stakeholders within the sustainable palm oil sphere. He was redesignated as Chief Sustainability Officer in April of 2022. He has 22 years of experience in corporate and advisory roles around sustainability, corporate responsibility, corporate strategy, program management, and change management across the plantation, forestry, property, telecommunications, automotive, oil and gas, and public sectors. And then finally, we're going to hear from AGNIESZKA, sorry, every time, excuse me, RACZYNSKA. She's the Migration Program Coordinator for Fundación Avena. AGNIESZKA is a human rights specialist with 25 years of progressive experience, driving strategies for civil society organizations to support human rights advocacy initiatives, activism, and more inclusive and participatory philanthropy. She has worked on projects centered on community development strategies, social impact, and facilitating cross-sector partnerships that drive innovative approaches to advance society within civil society and philanthropy. So as I said, I'm very excited that we have all three panelists with us here today. And I think we're going to start with ANASUYA in the room. ANASUYA?
Thank you, Neha, and I hope my mic is working and I'm audible. My remarks will focus on the progress and challenges in the import ban space, import bans against products made using forced labor in global supply chains. As part of the Human Trafficking Legal Center's activities, we focus quite a bit on how we can leverage trade measures like import bans to improve conditions across the supply chain. And this is in part because of a recent resuscitation of Section 307 of the US Tariff Act of 1930. This happened in 2015 through an amendment under the Obama-Biden administration. And through that amendment, we were able to see how US Customs and Border Protection has been able to enforce this law, issue import bans, or what we call withhold release orders, against a host of products and actors from different parts of the world for using forced labor in US supply chains. So just to give you a picture of enforcement to set the stage, so since 2015, since the amendment went into force under Section 307 of the US Tariff Act, Customs and Border Protection has issued 35 import bans or withhold release orders prohibiting goods from certain companies and regions from entering the US market. This includes apparel, fish, electronics, tobacco, palm oil, rubber gloves, and I'm sure we'll hear more from the other panelists on some of these particular products in the context of certain countries. So while the import prohibitions are just the first step, I think what we're all really interested to see is how forced labor remediation follows in this process. So, but before that, I do want to bring your attention to just some statistics to show why we are all interested in this space, why the Human Trafficking Legal Center has been so focused on issuing guidance to other organizations to engage with this tool, to engage with US Customs and Border Protection, to share evidence of forced labor from wherever they're working around the world. And we published a guide in 2020 called Importing Freedom, using the US Tariff Act to combat forced labor and supply chains, and we've translated it into a bunch of languages, including Bahasa Malay, Thai, French, and Spanish. So in fiscal year 22, US Customs and Border Protection targeted more than 2,400 shipments valued at $466 million US dollars because of forced labor concerns. Now this is a big statistic compared to fiscal year 2018, when US Customs and Border Protection detained only 6 shipments. So we've seen this sort of meteoric rise in enforcement, and with that, we've seen CBP, US Customs and Border Protection, engage more and more on issues of forced labor remediation. So as more companies are being targeted by this law, as more companies have their shipments blocked at port, we're seeing both Customs and Border Protection, the companies that are targeted, and also civil society kind of engage together to make sure that the workers who we want to be, who we wish to see as the ultimate beneficiaries of the law, actually see improvements on the back of Tariff Act enforcement. So a company that's targeted by an import ban or a withhold release order can petition US Customs and Border Protection to get itself removed from the withhold release order and resume exporting to the US market. But to do so, it has to show that it has remediated all the ILO indicators of forced labor that Customs and Border Protection has identified before issuing the import prohibition. So the US Customs and Border Protection generally follows the ILO framework in assessing and categorizing the evidence of forced labor it receives from petitioners around the world. And then it determines whether each of those indicators have been remediated. Now, recently, in the last, I think, 6 months, Customs and Border Protection has removed certain entities from various import bans as a result of the evidence they presented on forced labor remediation. And most notably, this has happened, of course, in the Malaysian context, and I see many experts in the room who can probably speak to the details on what's happening in Malaysia. But just to give you a sense of the reimbursement that has happened around recruitment fee payments in the Malaysian glove industry and the palm oil industry. In a CBP press release a couple of months ago, the agency mentioned that CBP's forced labor enforcement efforts have resulted in the improvement of living and working conditions for tens of thousands of workers, including the repayment of more than 50 million in withheld wages and recruitment fees that were used to trap workers in debt bondage. Of course, I think there has also been a ripple effect, even though there are only certain industries or certain companies that have been targeted under a withhold release order. We've seen other players in the same industry take proactive steps to ensure that they are not subject to a withhold release order. So maybe others, including I'm seeing Andy Hall, might have the latest figures in terms of reimbursement. But this 50 million is significant because it has happened on the back of US Tariff Act enforcement. Now, the Human Trafficking Legal Center is part of a coalition of organizations called the Tariff Act Advisory Group. I see a few members here. Hi, Sean. And we together we advocate for more robust enforcement of these import bans to make sure that we can enhance its impact. And in 2020, we did write a letter to US Customs and Border Protection. We write letters, we make recommendations on how forced labor enforcement can be done in a better way. And in 2020, we wrote a letter specifically on reimbursement of recruitment fee payments. And in 2020, I think that was the beginning of a slew of withhold release orders against gloves and palm oil in Malaysia. And we realized that all of the negotiations around reimbursements were taking place, and we were worried that maybe the numbers might be too narrow, that this exercise will be viewed in a really narrow way without taking into account the broader context of forced labor remediation and ultimately remedy to workers held in forced labor in those contexts. So in this letter, we made a few recommendations, and I just want to note a couple of them. The first one is that we urge the agency to think of recruitment fees in a broader context. We urged the agency to also consider whether they can require the company that's been targeted by a withhold release order to pay liquidated damages along with the principal amount of the recruitment fees to account for all the incidental costs around recruitment when the workers first applied and paid these fees. Because what we realized is there was a sort of patchwork of recruitment fee payments flowing out to workers depending on nationality, depending on which corridors they use, and a host of other factors. So that was one of our recommendations based on similar provisions under a US law, the Fair Labor Standards Act. Another recommendation was that we urge the agency to look at the date from which these calculations are made. That this has to be a date certain in the past. It cannot be arbitrary, and ideally it should be from the time that company first started hiring migrant workers, foreign migrant workers. And then one big issue was that of staggered repayment. So in the beginning, we saw very staggered repayment plans, often spread across 2 or 3 years, and then we pushed the agency to make sure that these payments go out in lump sum and not as staggered repayments. So these were a few of our recommendations, and we continue advocating on many of these issues, especially at congressional hearings. The Human Trafficking Legal Center recently testified at a few hearings on forced labor issues, and we did raise these issues on forced labor remediation. In conclusion, and I know there's going to be robust discussion later on, I think I do want to end by saying that recruitment fees, in our perspective, is one of the most pervasive forms of exploitation in global supply chains. It is a gateway to more indebtedness and forced labor, but the reimbursement exercise of recruitment fees should not be seen in a vacuum. It should occur in a larger context of remediation, which is full payment of back wages and other earned compensation, reimbursement for costs incurred on the job, reimbursement for forced overtime, regularization of immigration status, among others. And it is our position, and this is going back to what NEHA mentioned at the outset, workers and worker representatives and independent unions must be involved in the decision-making process, including the very design and implementation of the remediation packages that are finalized under the Tariff Act processes. And with that, I turn it back to NEHA.
Thank you so much, ANASUYA. I love when panelists stick to their time. You guys are wonderful, and I know we had a planning call, so we're on it. Rashid, we're very excited to hear from you, and I think we all just owe Rashid a big thanks, because I think it's like 3 o'clock in the morning. He's in KL, in Kuala Lumpur, I think, in Malaysia, and it's very early. So Rashid, thank you so much for being with us so early in the morning. Please, go ahead.
Thanks, Meha, and thanks to the IHRB for inviting us to share some of our experience around ethical recruitment and also the sort of experience that we've had in the past couple of years in implementing repayment of recruitment fees. So we'd just like to share our experience and some of the practical challenges that are happening on the ground with regards to implementing some of these things. So I mean, there's a few points that I wanted to get through today at the start of this session. The first one is essentially, I'll probably give a quick overview of ourselves and our operations, just to give a bit of context of where we are coming from. Then I'll touch a bit about the process that we did with regards to the reimbursement of the recruitment fees of our existing workers, and also some of our ex-workers as well. And also I'll touch a bit also about some of the enhancements that we've made to our ethical recruitment processes. So just to start, to just give you an overview and context to the people here today, SYAM Plantation, we are mainly a palm oil company. We operate across the entire value chain of palm oil, but the majority of our operations are in the upstream operations, which is essentially the estates and mills. And basically, if you just zoom down to our Malaysian operations, this is basically where the sort of risk of forced labor is highest, because in Malaysia itself, in total we have more than 20,000 workers in Malaysia, and at one point in time, up to 80% of the workers are migrant workers coming from more than 6 different nationalities. So there we actually have quite a significant amount of migrant workers who are working with us, and on an annual basis, we actually get in the thousands of workers coming in on an annual basis from these different corridors. So we actually previously already had a zero cost recruitment policy back in 2016, if I'm not mistaken. But what we found out was, when we conducted an assessment on our operations in Malaysia and interviews with workers a couple of years back, we found out that even with our policy and process back then, we found out that our workers were still paying certain amounts of costs. Certain amount of costs were still being incurred by the workers who came to work with us. So a few things that we decided once we found out about that. So number one, we made a public commitment on committing to reimburse the recruitment costs which were incurred by our workers and former workers. And basically we then started to focus on at first reimbursement of recruitment fees and costs for our current workers. So what that entailed is essentially around number. The key question that we had to ask was, how much do we basically pay back the workers themselves? So what we did was, we worked with an external third party, Impact. So Rosie from the previous panel just now, her organization, we worked with them to essentially interview a significant amount of our workers to try and understand what are the costs which were incurred by them for each and every nationality. So what happened was we actually then landed on a number based on the interviews with workers of what is the costs incurred by nationality, and we applied several things which included interest, opportunity costs onto that number itself to then land with a final number. So once we had the number for each and every nationality, and the numbers range based on the country that they come from, we then undertook a large worker communication and engagement process to basically try and explain to the workers themselves, number one, what this payment is all about, and why they are getting this payment, and the amount that they'll be getting paid. So there's a large scale sort of communication process to try and explain to them the reasoning behind that. And then what we also did was we opened up our grievance mechanisms and grievance channels to them for them to then call up in the event that they have any questions. And once that particular process has been conducted, we then basically transferred the sum of money into their individual bank accounts as a lump sum. So some companies actually decide to pay it in stages, but we decided to make a lump sum payment one-off. And then we got a third party to then come in to validate that the payment has indeed been sort of banked into each and everyone's individual bank accounts. So that is essentially with regards to the current existing workers that we already had, and at this point in time, all of our existing workers have already been repaid already. So if you were to move on to former workers, so this is where it got a bit more challenging, because number one, they're no longer working with us, and they're all spread out across the various countries where they originate from. So the first thing that we did was basically we actually then set up a sinking fund, where the amount of money owed to our workers were then put into a sinking fund and set aside, and cannot be touched. And then we also set up a sinking fund governance committee, where the representatives of the sinking fund of this committee essentially is to oversee the process of reimbursement from that particular sinking fund, and the members of the committee revolved around a senior independent director and an external legal counsel, and some of our senior management team as well. So they basically had oversight on this particular process of reimbursement. And the second thing that we did after that was we then hired legal counsel in each and every one of our source countries to basically be our representation there. And once that has been set up, we actually conducted another huge round of marketing, communication, and outreach program to try and reach as many of our former workers as possible. And the process is then, if they were a former Sime Darby plantation worker, they can then come to contact the local legal counsel, and there's an application process where they needed to provide documentation to basically confirm that they have previously worked with us, and we will then the legal counsel will then validate this on our records. And once it's been validated, basically the funds will be transferred into their bank accounts as well. So this is basically.
I'm going to give you the 1 minute warning. So sorry, go
Okay,
ahead.
sure. So I guess that the challenge with regards to that was essentially around trying to reach as many of our workers as possible, and also to validate that those people were indeed our workers. And the second challenge is basically to make sure that there was no representatives who are acting on behalf of workers as well. And the third one I wanted to quickly talk about was essentially around our ethical recruitment process, where we previously we already had a previous version of our ethical recruitment process, and based on the experience that we've had, we actually looked at further enhancing it. We actually are working with Andy. I think he's in the hall now, to actually relook at how we can improve on our ethical recruitment process to minimize the risk of workers paying any fees or incurring any cost once they are selected to be hired by us. And this is basically, I can go on and on and on about talking about this, but this is where a lot of work is currently being done on the ground to try and practically implement our zero recruitment policy. But I'll stop there for now, since Neha has given me the time warning.
Thank you. And I think we'll have that. You left us with an important point, and so I think we'll be able to get into that in the Q&A. Next, we have AGNIESZKA. Please go ahead. And AGNIESZKA, I know you can't see me, so I can't give you warnings, but I'll interrupt you. I'm sorry. But
Thank
hopefully
you.
you'll have plenty of time. Go ahead.
Yeah, thank you, Neha. Just interrupt me and I'll stop. So I prepared some notes yesterday for this conference, and then when the event started, I started to scratching all my notes and writing new ideas, because I just found out that what I was going to say was already said by other people. But then I thought, this is incredible, because this only shows that we all have a common vision of the change that needs to happen, and we all are looking for the best way of achieving that transformation and that change. And I hope to contribute to this conversation from a funders and philanthropy perspective, as we are not experts on repayment and remediation, but we do work with grantees, and I would like to share some of the experiences of some of our grantees on the ground, especially those working in Mexico. And I would like to take the opportunity also to send a message to other funders following this forum on the need to invest in labor rights, in the labor rights agenda, especially in the Global South and especially in Latin America. So Fundación Avina is a global organization rooted in the Global South that works through collaborative efforts to promote systemic change. We work as connectors, but also as investors by providing funding to diverse initiatives, mainly in Latin America. We currently are leading the Periplo project, supported by the Walmart Foundation, of a group of civil society organizations working in Mexico that aims to contribute to the creation of a more equitable labor migration system in the agricultural supply chains. First thought I would like to share with you from our experience is that collaboration is hard. It's really hard. Takes a lot of time and effort, but it's also necessary and it's urgent. And I would like to say this because I can see the potential in this room, and each time we shake hands, we know that we should collaborate more and be more proactive in the collaboration. So based on the information provided by Periplo partners, it's clear that the Mexican migrant workers face enormous obstacles in accessing repayment. And based on the information gathered from our partners on the ground, we haven't heard of a single case of repayment initiated proactively by an employer. And for a grievance to occur, the worker needs to go through a very complex process. The experience of our partners usually shows that the company will try to avoid the repayment, and the local context will make it harder for the worker to access the payment. A lot must happen before a worker receives his or her repayment. It is imperative to note that this doesn't happen, the repayment doesn't happen without the support and the commitment of civil society organizations, unions, or lawyers who support the workers and engage in a long and sometimes very expensive process. The Periplo project has brought together a diverse group of organizations that are sharing a common vision of the transformation that needs to happen. The Centro de los Derechos del Migrante and Tlachinolan, working in supporting workers in the community of origin, Cierto by promoting a responsible recruitment model in Mexico and the US, Stronger Together and Verite, engaging in promoting best practices among growers, just to mention some of them. And through the work of these organizations, we know that there is an enormous power imbalance between Mexican agricultural workers and their employers and the intermediaries. There have been some improvements, but those have happened because of the pressure and efforts of workers and their organizations that are supporting them. Additionally, most CSOs do not have the capacity to deal with all the cases. Rachel and Joe already mentioned this morning the number of workers that increases every year. And in order for repayments to be sustainable, it is vital that employers, buyers, investors, governments, and regulators work together to ensure the adoption and implementation of responsible recruitment systems. We at Avina and at Periplo believe in the collective and individual power. We will support the efforts of civil society organizations accompanying migrant workers, and we see the need to keep investing in educating migrant workers, but also in educating and informing employers and promoting human rights due diligence perspective that includes the recruitment process and ensures accountability of agencies and companies. And also, there won't be a best practice approach without workers' participation. And second thought of this evening, ensuring workers' participation is very challenging, but is, again, needed and urgent. It was really exciting to see Maritza Perez Obando this morning and Gerardo Reyes participating in this event. And we need to keep supporting their participation and listen to their experiences. I counted yesterday at least 7 people that were working together in different countries, ensuring that Maritza could participate virtually today. So it takes a lot of effort. It can be done, and we need to keep doing it.
AGNIESZKA, one more minute, please.
Thank you, yeah. So workers, rather than being passive recipients of payments, must be involved and included across all key stages of repayment process, including investigation, repayment calculation, verification, etc. They must be part of any solutions to any problem. Building community and building trust and power through information and effective participation is key. Lastly, and just to finish, through the Periplo project, we are promoting the adoption by companies of the human rights due diligence in line with the UN guiding principle on business and human rights. And just to share with you, we have started a community of practice on human rights due diligence in Mexico. They started to meet last year, and we hope to continue strengthening this ecosystem of diverse stakeholders in Mexico and keep promoting the collaboration among this group, collaboration with a purpose, and that is promoting an inclusive and effective dialogue, which we find key to achieve any success in the transformation that we are looking for. Thank you so much.
Great, thank you so much. And so I have a number of follow-up questions, but in the interest of as much as we can do in this hybrid situation, having a dialogue, I'd like to just ask Bonnie in the room to maybe raise the first 3 questions from the audience, either virtual audience or the ones in the room that have come up. Bonnie, maybe we can take 3 questions at a time. I don't want to overwhelm, but I think more than one is probably a good idea.
Okay, so we have a lot of very good questions. I think since we have time, it might be easier 2 by 2. They're thematically related. The first question is, well, we have one participant who's asking, are there scenarios where the U.S. forced labor import ban is not conducive to remediation, you know? And if this is the case, are there lessons that could be drawn to go into the draft EU proposal for a similar forced labor import ban? So what could Europe do better? That's the question. And then I know the last speaker spoke about migrant workers should be involved in the process of, the whole remediation. We have another participant asking, are there concrete examples where they're involved in all stages of the remediation process? The last 2 questions, I could raise it now, perhaps, or later? Okay, now. Is on the theme following up from the last session, which is about call sharing. So one question focused on, is it your impression that large-scale repayment is rare in the case of the withhold release orders? And if so, how do we push for repayment on a broader scale, as WROs will remain rare? And the second question, the second subpart, is call sharing again, following from our previous session on ethical recruitment. Do you think that buyers and brands should play their part in taking some of the burdens of remediation, rather than just leaving it to the suppliers? So, how would this look like? Thank you.
Thank you so much. And I think that's Bonnie. I was told your name was Bonnie, so thank you
so
much.
Thank you.
Why don't we start with ANASUYA, because there were a few questions there related to the U.S. Tariff Act and WROs. And I know, ANASUYA, I can't see you, but I know that you also through the tag, which we're members of, we've been also engaging on other due diligence models and other similar trade mechanisms like the Tariff Act outside of the United States. So those 2 questions that were sort of related to that. And then AGNIESZKA and RASHYID, just to prepare you, RASHYID, I think from your specific example, how you're dealing with some of the things that were raised in regarding workers specifically, and then the role of companies. And then AGNIESZKA, I think you heard the questions that were targeted towards you too. So why don't we go ANASUYA, AGNIESZKA, and then RASHYID. Go ahead.
Great. And I think I might start with the first question that you posed to me, Bonnie, around whether WROs can be fit for purpose when it comes to remediation in all cases. In the case of state-imposed forced labor, we draw the differentiation there. But at least for the purposes of our discussion today, I think in most facility-specific or fishing vessel-specific or farm-specific WROs, there is potential to engage in meaningful forced labor remediation, provided we have inputs from civil society. Workers on the ground are able to independently monitor and verify the situation and verify their situation, and they are part of the very design of the forced labor remediation process. Now, this is something I forgot to mention during my remarks. This entire process is not baked into the statute. It is not baked into the import ban laws in the United States. And I know that there's efforts by our partners in the EU to have a more remedy-focused instrument in the EU import ban or market placement mechanism, however you want to call it. So I think that's something we have to keep in mind, that in the U.S. Tariff Act, the section itself, there is nothing that prescribes how forced labor remediation should happen through this process. It has evolved over the last 4-5 years. We've actually seen good progress and understanding from Customs and Border Protection in how remediation might differ from region to region and product to product and sector to sector. And it's part of our continuing advocacy push to ensure that there isn't an over-reliance on just one mechanism as a silver bullet. There isn't an over-reliance on just social auditing. There isn't an over-reliance on, these corrective action plans. There isn't an over-reliance on companies making promises and then being able, there isn't an over-reliance on companies just coming out with, more codes of conduct and plans for future implementation. So through this process, CBP has, at least in the past 3-4 years, been more discerning about requiring proofs of payment around recruitment fees, proofs of payment around back wages. So I think that is definitely some progress. And I think there was another question on whether large-scale repayments are rare in the WRO and import ban context. I think the Malaysian example will show that it has been happening en masse, and more than, as I noted earlier, more than 50 million at least in recruitment fee payments and back wages have gone out to workers through the WRO process. So hopefully we can only scale up from there. And then I don't know if I missed a question. I was trying to write down everything, but maybe Neha, back to you if you want to.
Thank you.
Yeah.
Thank you, Anasuyya. And I must say, and it should be really interesting to hear your thoughts on this. I don't know why it's echoing all of a sudden. Are you guys hearing that too?
Yes.
Okay.
Okay. Yeah, thanks, Meha. So I think
Sorry.
yeah. So I think I'll touch a bit about the question around the responsibilities of the actors across the supply chain, because that's one area where we actually are looking into as well. Because if you look at with regards to the implementation of the sort of interventions that we put in place, things like our ethical recruitment process and our remediation process, all of those sort of interventions were basically funded by us. But not all companies are able to sort of invest as much as ours. So essentially, I mean, the point I wanted to raise is that for us to basically have more holistic change for the industry itself, we need all supply chain actors to basically play a role, and there needs to be a shared responsibility between the upstream, downstream, and consumer goods products, and all the way up to the end consumer, on the expectation, number one, the expectation of ethical recruitment of migrant workers, and also the remediation of any recruitment fees or recruitment costs. I mean, an example that I can give is essentially, we are already partnering with one of our customers who is co-investing in implementation of grievance mechanisms in our own operations, because they also feel that because they are attached to our supply chain, they need to make sure and invest in making sure that their supply chain is also free of forced labor. So what would help the industry itself would be more and more of these sort of collaborations across the entire value chain and co-investment as well, so that we can have a more holistic change and improvement of migrant worker rights. I think I'll stop there for now and hand it back over to you, Neha.
Rashid, and I was trying to say before there was an echo, one of the things.
I think the echo is you, Neha.
It is. Maybe if you Rashid, I think you yourself might not. Thank you. Okay. So I was saying echoing. Well, just very quickly, maybe Anasuya, you talked about this a little bit since my voice is echoing, but one of the other things that we talked about in regards to the question is ensuring that there's some sort of worker emergency fund or worker remediation fund, that if employers are going to use recruitment agents, that they have to pay into a fund or there's a bond, so that workers aren't left high and dry if companies cannot pay the recruitment fees. So just one of the things to think about, and there's more details about it, maybe Anasuya you talk about. But NEHA, do you want to respond to any of the questions?
Yeah.
I could Jump in just for a second. Neha was talking about how some of us in our coalitions have conceptualized in very early stages about a tariff act, a worker emergency fund, which is financed, well, we'd hope that it would be financed by penalties that the US government can impose on the US brands and buyers for importing products made using forced labor. In 2020, the US government issued its first ever forced labor penalty against Pure Circle, a stevia company, for importing stevia made using prison labor from China, which was not a big sum, a $575,000 penalty. We haven't seen a single forced labor penalty since. So when that came out, we were excited at that money goes to the Treasury, the US Treasury, by the way. So when that came out, we were excited by the prospect of having that getting channeled into a worker emergency fund to offset some of the challenges that can come immediately once a WRO is issued. So I think probably that's what Neha was talking about.
Yes, thank you, Anasuya. AGNIESZKA, do you want to go ahead?
Yeah, thank you. So about the question of concrete examples, I was cheating actually and asking Rachel if she could provide concrete examples of cases of workers participating in the whole process. And yes, I mean, we've seen workers receive reimbursement through collective organizing and approaching the employer. And Rachel was sharing this with me by WhatsApp that when they organize, approach the employer and demand repayment, that's when it works. And when they don't get the repayment, they reach out asking for help, and usually they reach out to the Centro de los Derechos del Migrante or their organization. I'm sure Cierto has had some cases. So I would ask Rachel if you could share a concrete example with the room. Maybe with the mic.
Hi, I'm sorry, just to interrupt. There's somebody who's close to wherever the Zoom is that's laughing and speaking, and so Rashid and I can't hear anything. So just to know that for anybody who happens to be near the laptop, we're only hearing you. So sorry. And if somebody in the room is speaking, if they can have a mic, it's hard to hear if they're not mic'd.
I'll turn it on, and maybe that'll help. Thank you. In terms of like the question, and honestly, it's sort of surprising for me because we have never seen employers voluntarily reimburse recruitment fees, like really at all. And we talk to hundreds and hundreds and hundreds of workers every year, and it's always through worker organizing, through workers approaching their employers. And when that doesn't work, taking other action, like legal action, filing complaints, filing lawsuits is what, at the end of the day, workers are doing to ensure that they get reimbursed. And we have lots of examples of those, but essentially that's what we've seen. So I can tell you one is and I feel like this might be Jose de Lira, a member of our Migrant Defense Committee, was recruited to work in the United States. When he got to the US, his passport was confiscated. In Mexico, he had been charged a fee as well. And he knew things weren't right because he had been through training, so he organized with his colleagues. They approached the boss. They asked for their passports back and their money. The boss refused. He called us, and then we called some local organizations who were able to go out and provide backup support in their engagements with the employer, and then got the Attorney General involved, and then there was a process through the New York Attorney General. So what I'm saying is like, employers typically don't turn over the recruitment fees voluntarily. It takes a lot of work on behalf of migrant workers to actually get the money that they're owed. And so I hope that was what you were looking for.
Thank you, Rachel. I just would like to end this panel with this image. It takes a lot of effort, a lot of people behind the workers to get repayment. So it's not, we often think about the worker and the employer and they talking and somehow the worker gets the repayment, but there's a lot of effort behind each worker and the work that the civil society organizations, union, lawyers are doing on the ground at the communities of origin and destination is key to succeed. So I thank you, Rachel. Yeah.
So again, I'm so sorry. There's somebody in the room that's having a conversation that just heard the words ITC. If you are talking about the ITC in the room, please leave the room because we can hear everything. And then unfortunately, Rashid and I can't hear it now. Okay, but I don't think we can change that. Anyway, and Bonnie, any more questions in the room? I apologize to people, I can't hear. So any other questions in the room, Bonnie?
Yes, we have more questions. We have one here asking simply, how many times should a company repay before the message is reached home? Meaning that they should not be charging workers recruitment fees and related costs.
Yeah.
Are there other questions you want to just go through them all since we only have 3 minutes left?
I could. I'm a bit worried about sliding over the
So
time
maybe just
because
ask
we need to have a
questions.
hard stop. Yes. Yeah.
Go ahead. 2 more questions.
No.
Sure. I mean, well, there's another question about repayment of fees. Should that be the only sanction? How should it be combined with the prosecution?
So, Anasuya, do you want to talk about that? Because in the recommendations that you discussed in your opening, there were recommendations beyond just the actual fees that workers pay. Or do you feel okay talking about that?
Sure, and I think maybe the first question to Rashid, probably, sorry to put you on the spot. So on prosecutions, I think one of the reasons why we have focused so much on the Tariff Act is because of how quickly it can affect the corporate bottom line and expedite some of these processes in countries like Malaysia. And then there was a petition that we worked on with members of the seafood working group to exclude fishing nets from Thailand that were made using prison labor. And just weeks after that went in and news of it sort of came out, the Thai government announced all of these policy changes to the prison labor system. Still requires a lot of work, and this was very specific to the production of fishing nets. But just to kind of highlight the importance of import bans as a mechanism that can be leveraged to expedite some of these changes on the ground, some things that we've been working on for years in many of these countries. Now I think the threat, even the potential threat of an import ban is prompting changes, and now companies are being more proactive. A prosecution, and I think this is something our organization, we also work on litigation, and but prosecution has been slow, and every year the Trafficking in Persons report will tell you how many prosecutions there have been in the whole world for forced labor, and you'll notice that it's a really, really small number when compared to the number of people that the ILO estimates are held in forced labor around the world. But that said, we don't want to see the import ban mechanism in isolation. It is complementary to a lot of other mechanisms. For example, when there was a vessel that was sanctioned by a WRO, and then soon thereafter there were also global Magnitsky sanctions imposed on the owners of the vessel. So the two mechanisms kind of like had the two mechanisms worked together, and there was some exchange of information between U.S. Customs and Border Protection and the agency and Treasury around this. We've also seen this happen in the context of Department of Commerce in the United States. They can impose, they can have a list of entities where U.S. companies and persons are prevented from exporting technology or expertise to those entities abroad, which is something what we call an export ban as opposed to an import ban. So there's a whole range of tools, and we've always encouraged a whole of government approach to addressing forced labor in U.S. supply chains. That includes, of course, prosecution. And we hope to see more prosecutions on the back of tariff act enforcement, because I think the evidence base for all of this starts at the same place, and then you can sort of develop on that and get more information.
Thank you, Olivia. Since you want the last word, I know we're out of time, so I'm just going to let you have the last word.
Yeah, so I guess I just wanted to answer the question about how many times does a company need to do reimbursement. I think that was the question. I think from our point of view, if a worker has incurred any cost to actually get the job, they need to be reimbursed. So the focus on our side is to make sure, and a lot of effort that's been put in place now is to make sure that these kind of things don't happen in the first place. So that's why we're spending a lot of time and resources in trying to practically implement on the ground, what does a zero recruitment cost sort of recruitment actually work, and putting in various sort of controls in place, working with agents and doing capacity building, doing a lot of awareness raising for potential workers. So to try and see how we can further improve our ethical recruitment process. And it's not easy, it's challenging, and although we also have a control only over a limited sort of scope, which is basically our the process of our own recruitment, but there are still other actors, and other stakeholders who also need to be involved in it. So a holistic approach to ethical recruitment with all actors in the sort of recruitment process should also be required as well.
Thank you all so much. A big thank you to ANASUYA, to RASHYID very early in the morning, to AGNIESZKA for traveling all the way to New York. Thank you to IHRB for inviting me. And again, I hope, as I said at the beginning, that the big takeaway that we take from this is the importance of workers and workers themselves being able to exercise their agency front and center on the issue of remedy and remediation, and not be seen as an afterthought or as beneficiaries, but instead the main stakeholders for all this. Thank you all so much, and good luck with the rest of the forum.
Thank you, Neha.